Hi, everyone. Thank you for joining the Immigration Brief. I am Naveen Bhora. I'm an immigration attorney and managing partner of WR's New York office. I'm joined today with my colleague, David Fullmer, who's a partner at our Los Angeles office. Hi, David.
Hi, Naveen.
All right. So today we wanted to talk about the critical issue for the global mobility community when you have US citizens and permanent residents who are based abroad and are now considering moving back to the US or repatriating, and just thinking about the concerns and logistics on their family members who may not have immigration status in the United States. They may not be permanent residents or US citizens. So let's dive into this, David.
Definitely, this can be a real challenge for mobility managers in international organizations because there might be this assumption or presumption that if the working spouse who is stationed abroad is a US citizen or permanent resident, there might be this assumption that they can just simply transfer very easily to the United States. But it's very important to think about the family unit because if the entire family is not happy on a transfer, it will not be successful. And so it's very important to think about, whether or not there is a way for the non-working spouse to be able to live in the United States. And also thinking about the children is extremely important because if this is not done correctly, the timing can really get out of control. It can take a very long time to sponsor a foreign spouse through the normal I-130 process.
Yeah, so let's talk about some key strategies and common scenarios. So we have, just as an example, to start with US citizens spouse who's working abroad. Sometimes there are individuals who became US citizens at birth through their parents, but never actually lived in the United States, right? They spent their whole life abroad. Or you have situations where someone has moved from the US office to an overseas office and have been living there for several years. And during that time, they got married, they've had children, and didn't really think about how to bring their spouse and children back to the US on a future move. So, what does the standard process look like, David, when let's say you have some time and you want to sponsor your immediate family member? What are the steps?
Recently, in my experience, if you go through the regular process where the U.S. citizen files an I-130 through the USCIS, waits for the approval, and then does immigrant visa processing at a U.S. consulate, it can take a year and a half, even 2 years. And looking at a real life example that we just completed at our office, we have a case that was processed through London that took 22 months. And, London is a post that, even though it's not quick, it's a very large post. And so I can imagine that in other parts of the world, it could take even longer. So if you go through the regular process, this can take a really, really long time that can be very disruptive to a family.
Yeah, even in that case, the kudos to the clients. They're very motivated. Whenever you needed a document, it was ready, right? So just imagine the process can take a lot longer if somebody doesn't have all their civil documents ready and things like that. Also, at the end of the process, when the individual receives their immigrant visa stamp, they have up to 6 months then to enter the US. So, just if you are thinking about going through this process in the future, right, just to plan it out, but then once they've completed the process, the family does need to move within that 6 month window. So, David, let's talk about exceptions to this 2 year long process. What can someone do when they don't have the luxury of waiting that much time?
There are some exceptions. There are certain situations where an I-130 can be processed at the U.S. consulate instead of originating at the USCIS. And this could be very helpful. It can cut time down significantly. And both the USCIS policy manual and the Department of State's Foreign Affairs manual give some examples of what's considered to be an exceptional circumstance where they would at least consider processing the I-130 at the US consulate. And the first one that's mentioned is military emergencies, where you have a member of active duty US military serving abroad and they perhaps become married to a US citizen and then end up transferring back to the US. That's specifically mentioned as an exceptional circumstance. Medical emergencies is also specifically listed as a exceptional circumstance. Threats to personal safety, where someone is under threat of harm in the foreign country, and the entire family needs to relocate back to the United States. Beneficiaries that are close to aging out. And then there's also a situation where someone is perhaps a beneficiary of a what we call a family preference petition, and the petitioner becomes a U.S. citizen, and so they need to quickly file a new petition. And that's an exceptional circumstance, a situation where a child is adopted and the parents are immigrating the child. Also, a situation where the U.S. consulates may consider processing the I-130. And the one that I really want to get into today is a short notice relocation to the US. And this is the one that really affects our clients with international organizations where the larger organization might want to transfer the US spouse back to the United States. And that short notice relocation is considered to be an exceptional circumstance, but there are some requirements. And the first one is that the petitioner needs to be physically living abroad and that no I-130 is already filed. In other words, what they don't want, and they specifically state this in the Foreign Affairs Manual and the USCIS Policy Manual, they don't want this exception to be used just to expedite an I-130 that's already pending. So this really emphasizes and shows how important it is to plan ahead because if the company transfers the US citizen to the US before they start the process, then this exception does not apply. Or if an I-130 is filed and it's pending, and then they start to look into whether or not the I-130 can be expedited by filing with the US consulate, it does not apply. So again, planning and strategy in advance is very important.
And then if you do want to go through this expedited process, then the individual really needs to reach out to the consulate and lay out their case for why they meet the requirements for this exceptional circumstance. And then hopefully at their discretion, the consulate will accept jurisdiction and then will arrange for the US citizen petitioner and the beneficiary family member to submit the application at the consulate and go through that process. And even then, this process can take 2 months, right? But that's still better than 2 years.
Definitely better. I've seen it take 4 or 5 months, but again, still better than 2
Yeah.
years. And it is discretionary. That's the other thing that it's no guarantee.
Right, right. One other thing to keep in mind for US citizens who are working abroad or permanent residents working abroad, that they need to make sure that they're being compliant with their tax obligations as well, because as part of petitioning for a family member, there is a requirement for an affidavit of support and you have to provide tax returns. So just to keep that in mind,
Need to pay those
pay
taxes.
the taxes. Yeah. All right, now let's talk about permanent residents. They're unique as well because the spouse of a permanent resident is not an immediate relative, and there is a wait, oftentimes for that F2A category for an immigrant visa number. So, what can a permanent resident do?
Well, there is one option that's perhaps seen as a little bit drastic, but could allow for the entire family to move to the US, and that is looking at whether or not it would be wise for the permanent resident spouse to actually abandon the permanent residency by filing Form I-407 and then being petitioned perhaps for an L1 visa. And so, again, they would be giving up the green card but they could perhaps move to the US quite quickly with the whole family and then be petitioned again for permanent residency, perhaps through an EB1C. So again, kind of a drastic move, but if you really prioritize keeping the family together and doing the transfer quickly, it might be something to look at. Of course, there could be tax consequences, right, Naveen?
Absolutely. So for all of these actions, always reach out to the tax advisors as well to make sure that any of these strategies are meaningful from a tax perspective and to understand what liabilities there are, for example, for a permanent resident to surrender their green card. The surrendering of the green card process requires the permanent resident to actually mail in the application to USCIS before you're able to do this at the consulate. Now it is a mail-in procedure with USCIS. That being said, the process isn't too bad. It's still about 2 to 3 months for USCIS to accept that application and then formally acknowledge that this permanent resident has given up or surrendered their green card. Once they have that, then the company needs to apply then for the appropriate work visa. And now we're back into looking at what is the best path for this individual, keeping in mind that H-1Bs are limited due to the annual cap. Do they qualify as an intercompany transfer? If this is a new unaffiliated company that the individual is joining in the US, then the L1 may not be an option, and then perhaps they qualify for an O1 as a person of extraordinary ability. If it's a treaty national, then potential E. Having had the green card, surrendered it, what does that mean for the E or an E3 as a Australian? So again, you may have to go through all of these strategic discussions to see if giving up the green card is viable, if there is a potential, path forward with a non-immigrant visa. But certainly that is the way to keep the whole family together, have everyone come to the US together. And I do want to caution also, just to go back on the US citizen wanting to bring their family members. The temptation, I think, is there for people to bring their family on a tourist visa or an ESTA and then remain in the United States and just apply for the green card within the US. But I do want to caution that there is, potential finding of misrepresentation or fraud if you are coming into the US with a tourist visa with the intention of staying and applying for a green card. So, although some people may think that would be the appropriate, fastest way to do this, there are risks involved going down that path.
Naveen, what do you think about the wisdom of a foreign spouse just accompanying the U.S. spouse on a short trip and then, returning and waiting in the home country for the visa? Is it okay to travel with the U.S. spouse on an ESTA or tourist visa with the ultimate plan of immigration, but no intent to adjust status?
Yes, and actually, just to go back to that earlier case we were discussing where someone completed the process in London, they were able to visit the US with their US citizen spouse a few times on ESTA, but had to be very clear that while they are going through the immigration process, it is at the consulate. They do have a pending I-130, but on this particular trip is just a short visit, and they're going to go back home and they will eventually complete the green card process at the US consulate. So, certainly that can come up if you are visiting the US often and staying for several weeks at a time with the US citizen spouse. But again, as long as you're showing that you're doing all the right things, the CBP officer, understands and will allow you to come in for that short visit.
Nabeen, what about children? If they accompany, they're not U.S. citizens for whatever reason, would they be allowed to attend U.S. public school while they're visiting the U.S. with the non-working spouse or partner?
Yes. So, you're not allowed to actually attend public school on a B as a tourist. So that would not be allowed. What you can certainly do is enroll the child in private school, but then they would have to make sure that they're getting the F1 visa for that private secondary school, for example, or for university, but certainly can't do it for public school.
Now, thank you for covering that. I think that's a common misconception because if you contact the school usually will not discriminate and will say that the child can enroll. But it's certainly a sign that there is intent to immigrate, and it could possibly cause problems for the parents who are trying to immigrate later.
Yeah. And so let's talk a little bit more about children. So, children of US citizens, is the child born a US citizen if they're born abroad?
The answer is, in some cases, they are. Um, the rule is that if the U.S. spouse has spent 5 years in the United States, and at least two of those were after they turned 14, then when they have a child anywhere in the world, that child is a U.S. citizen. And the procedure is to file a report of a birth of U.S. citizen abroad and apply for a U.S. passport. And then that child will be a U.S. citizen and will be able to, again, come to the U.S. without having to worry about a visa. So that's something that's there. Naveen, are there time limits? Does it have to be done by a certain age? How does that work?
Yeah, so all the instructions, especially, the consulate, they're very clear that this needs to be done before the child's 18th birthday. There are so many little rules about transmission of citizenship. So you just want to be very clear and do the research to see if the parent has, can meet those physical presence requirements to transmit citizenship. And then in some cases, we've been successful in ensuring that the grandparent meets those physical presence requirements. But it takes a lot of digging to establish physical presence for someone. They can be things like transcripts from university or high school, tax returns, social security printouts, things like that. But a lot of digging to produce the evidence of, that someone was actually living in the United States like decades ago. And now, if there isn't the physical presence to transmit citizenship, then the process is very similar to the spouse, where you would apply for the I-130 for the child. And if they're able to get that exceptional circumstance and get it done at the consulate, that's great. Otherwise, you are going through that longer process of first filing with USCIS and then going through the National Visa Center and eventually going for the immigrant visa interview at the consulate. Once the child has entered the United States, though, as a permanent resident, they automatically then derive citizenship. So they do need to first step foot in the US as a permanent resident. And then, as long as they're in the physical custody of that US citizen parent, they then derive citizenship. So it is an additional step to have to go through that permanent residence process. But as soon as they arrive here, admitted as permanent residents, they then become citizens without having to go through a naturalization process, let's say 5 years later.
So if a child is able to derive U.S. citizenship from the parent, they go through the process that you described. Are there any other steps that you would recommend so the child would have proof that they're a U.S. citizen going forward in the future?
For children who derive their citizenship, this could be through that step where they enter the United States as permanent residents with their US citizen parent, or even situations where the parents are permanent residents who naturalize in the United States and have children under the age of 18 who derive citizenship. First of all, they can just go and apply for their US passports. But in addition to that, we are also recommending obtaining certificates of citizenship so that they have an additional document or evidence of their citizenship, because in the future, if they ever need to petition for someone else, just having a US passport may not be enough. And then they would just have to trace back how they became or how they derived their citizenship through their parents. So, best to do that certificate of citizenship now, if possible. And I've also, heard from some of our clients that sometimes the country from which they're immigrating from, that country may also require further proof that they're US citizens and that the passport may not be enough. So we actually have this case for children who were Spanish citizens, and the Spanish government actually wanted to see certificates of citizenship, not just the US passports.
That's a very good point, Naveen. And I think it's a step that's often overlooked because, from a practical perspective, all that you need to travel is a passport. In fact, a US passport's good enough for travel, it's good enough for an I-9. But looking ahead, having that certificate of citizenship may be useful. Another point that is important to bring up is that some countries do not allow dual nationality. Just some examples that I can think of are Austria and Japan. There are probably others as well. And so there have been situations where I have recommended citizenship, and I've been told by the foreign national that that's not possible. That's not something that they would consider because it's not allowed in their country. So it's something to look at as well as, is dual nationality allowed?
Absolutely.
Can we talk about using non-immigrant visas as an option if for some reason it's not possible to expedite the I-130 and we have a U.S. spouse who's transferring pretty quickly? Is a non-immigrant visa ever a good option for the non-working spouse to be able to relocate to the U.S.?
It is if the spouse is a professional and qualifies for a work visa. So if they qualify on their own for an intercompany transfer, L1, for example, that's fantastic. An O1 as a person of extraordinary ability. But just to caution that other work visas where you can't have immigrant intent, the ones such as, a student visa or an E3 or a TN, treaty NAFTA, those visas can be tricky if you're married to a US citizen, right? Because you can't have the desire to live in the United States permanently. And so you would need to explain to the consular officer, for example, if you're going for that E3 or that student visa or a J1, that this is just a temporary assignment and it is your intention to go back to home country.
It's a very good point, Naveen, because I think the knee-jerk reaction is that if the person is from one of the 5 treaty countries, Canada, Mexico, Australia, Singapore, Chile, that perhaps, and if they have a job offer, maybe it's even the same company the other spouse is working for. If they have that employment, they would be able to move to the U.S., and that might be the case. But that intent issue is something to look at very, very carefully. I guess it's the same with study, right, Naveen? I've had some people ask me, well, can my spouse enroll in an MBA program, and can we use that as a methodology of coming to the U.S.? Again, the student visa is not a dual intent visa. And while that might be a viable option, you have to look at what the couple's long term plan is. And it would only really work if the plan is to be residing in the US for a period of time and then returning. So I think the takeaway from our discussion today is that in a situation where you have a US citizen or permanent resident living abroad and you have a need to transfer the entire family to the United States, it's a complex issue. It needs to be looked at in advance, planned out very carefully. You need to look at different options. You need to look at the tax consequences and work very carefully with your immigration counsel to make sure that this type of transfer happens smoothly.
So we're happy to talk through these specific cases and help employers navigate through these complexities. Drop your questions or comments or reach out to us directly. And please stay tuned for more insights in our next session. Thank you.
Thanks for joining us.